make this program possible are provided by the City of Highland Park. Programs are produced independently by members of the community. The City of Highland Park is not affiliated with the following program or the producers of public access programming and is not responsible for the content. The following program does not reflect the opinions of the City of Highland Park.
Welcome to Chill Out. I'm Pam Chill. I'm one of the Highland Park senior producers, and I'm very fortunate today to have as my guest Melanie Witt. Thank you. Welcome, Melanie, to the program. Melanie Witt is going to be talking about estate planning and 4 essential documents that everyone needs to do a proper estate plan. Before we begin into that, I did want to read a little biography about your credentials. Melanie Witt has been a well-known estate planning and business succession attorney for over 20 years. She represents corporate fiduciaries and individuals in estate planning, philanthropic planning, and trusts and estates. Melanie has extensive experience advising entrepreneurs on business succession planning and estate structuring. She also advises clients on premarital agreements as well as estate and tax issues raised by divorce or separation. Prior to establishing her own firm, Melanie was a partner in a large Chicago law firm. Prior to that, she was vice president and trust counsel at BMO Harris Bank, where she addressed trust and estate litigation, risk management, and fiduciary responsibilities. Melanie earned her BA with high honors from the University of Michigan, her JD from the University of Notre Dame Law School. She was also awarded a Master's of Law in Taxation from DePaul University College of Law. And you did receive, tell me about the Martindale-Hubbell peer review rating. Tell me a little bit about that.
So that's that is a rating by other attorneys where they'll send letters to attorneys saying, do you know this attorney and what do you think of him or her? And then it gives your peers the opportunity to sort of anonymously rate what your opinion is of that attorney's skills.
Well, that's wonderful. I mean, that's quite an honor to establish such a relationship with your peers.
I guess I didn't make very many enemies.
Okay, and she's also selected for inclusion in the Register of Women Lawyers since 2010. You co-authored a chapter on income taxation of trusts in the ICLE on trust administration, and she was named one of the 10 best estate planning attorneys in Illinois by the American Institute of Legal Counsel. Melanie is a frequent speaker on various issues related to estate planning, business succession, legal ethics, and charitable giving. Melanie is also licensed to practice law in Illinois, Wisconsin, and New York.
Thank you.
Yes. All righty. So we have 3 states. You only have 47 more to go, right?
Exactly. I'll start working on it.
Well, we have a lot of people who are snowbirds. We were talking about that before the show. Right. And, how does, while we're on the topic, vary from state to state on estate planning laws?
Most states, as long as it's not a community property state, most states' estate planning laws are fairly consistent. Particularly, a lot of the states have adopted what's called the Uniform Trust Code, or the UTC, which is really nice because it makes it a lot easier for people who move around. We were talking about this before the interview, that things have changed. People were, I used to, when I was a young attorney, I used to know people who had never left the state of Illinois. Now we're international, and I have clients all over the world, and certainly all over the country. And so it certainly is a challenge as an estate planning attorney, which is one of the reasons why I'm admitted in Wisconsin and New York. If a community property state like Arizona or California, I will, I defer to the community property attorneys for that. But it certainly is a brave new world in terms of estate planning. Simply, we have to we have to be able to service our clients wherever they are, and sometimes it means working with another attorney outside the state to work with the client. So it's a challenge. It's very different from when I first started practicing law, and I'm dating myself, but internet was just the beginning, and it was fax machines was the major communication. So it's certainly, we're all very connected. So.
Very connected, absolutely. So tell me about, because the show is entitled 4 Essential Documents. So tell me what these 4 essential documents are.
So the 4 basic documents that everyone needs, pretty much without fail, no matter what your status is, married, single, what your assets are. If you're over 18, you need a will, powers of attorney for property and health care, and most people need a living trust as well. And a lot of people don't realize that, how important it is to have an estate plan. I can't tell you how many clients have come into my office where they've been very lucky and they're in their 40s or 50s and have never done an estate plan, and they just say, well, you know what, if worse comes to worse, if I don't have an estate plan, we'll do probate, it'll go to my wife. And that's not the case. If you don't have a will, basically any property in your name passes via what's called intestate succession, and each state is a little bit different. And for example, in Illinois, if you don't have a will, any assets in your individual name, and that means not with a beneficiary designation or joint tenancy, will pass via intestacy. And if you're married and have children, it would go half to your surviving spouse and half to your children, which people don't realize that, because a lot of people, most people would like their spouse to benefit if they're married from their assets during their spouse's life and then pass to the children. And another layer of complexity is if people have minor children, because then it's a real nightmare if something happens and they don't have an estate plan in place, because not only does it pass half to the spouse, but half to the children in a guardianship, and you have to open up a formal minor's guardianship to administer the assets, and the surviving spouse has to go to court, have an attorney, hire an attorney like me to go to court pretty much every time they need money distributed, and it can only be used for those children. So it's really important, particularly if you've got minor children, to look at your estate plan and make sure you've got what you have in place. Because I know a lot of estate planning attorneys talk about estate taxes and mitigating estate taxes and avoiding probate. But the important thing is you don't want the tail to wag the dog. The important thing is you want to have an estate plan in place so that your assets go in a way you want them to go. This can be done with just a will, but a will and a living trust is a much better vehicle, because, and again, a lot of attorneys push, avoid probate. A decedent's estate, if you die and we have to probate your assets, it's like 6 months to a year. It's relatively painless, but if you become disabled and your assets are not in a living trust, if they're in your individual name, it's like the minor's guardianship account. It's these draconian rules. The assets can only be used for the disabled person, and I've been practicing law long enough that I've had clients who, I had a gentleman who had a reaction to a flu shot and was in basically a coma for 6 months. And we had to do a guardianship estate for him. And all of the assets, the couple's married assets, joint assets, were all in his name. And it was a nightmare. So really planning for death and disability is the really important thing. And when I say death, not just avoiding probate, but making sure on your death your assets go where you want them to go. And so that's where a living trust kicks in. A living trust is basically, it's created during your lifetime. Typically, you're trustee of your own trust. So basically,
so you can control it. I just wanted to interject. You can control it, and someone else is not making decisions as where if you want to sell your home or if you want to move stocks around or whatever, you control it.
Right. Okay. I mean, you've unfettered control. You can amend it, revoke it. I mean, I have clients who literally are on their 13th amendment to their estate plan. So, you're trustee. So, I mean, it really is the best of all worlds. But if something should happen to you and you become disabled, you're in a car accident, or you get a terminal illness where you become unconscious. The successor trustee, whether it's the surviving spouse, adult children, a bank, can step in and seamlessly pay your bills. Nobody has to go to court. Nothing's public record. It's very discreet, and it's relatively painless versus a guardianship. And so that's really, the longer I practice, the more I realize it's really important to having living trusts. And a lot of people think, oh, I don't have enough money to have a living trust. Everyone should pretty much have a living trust, just because there's no reason not to. You still have a will, because it's called a pour-over will. And it's just a few pages and says, anything in my individual name pours over to the trustee of my trust. It's a belt and suspenders, because to the extent that you retitle assets in your name as trustee, let's say you create a living trust, all your bank accounts, if you have a home, everything would be titled in your name as trustee of your living trust. That way, if you became disabled, there would be no guardianship. Then if you died, under Illinois law, if you have no real estate in your individual name and no assets in your individual name over $100,000 combined, not individually, but combined, you don't have to do a probate estate. And so it's so much easier on the family as well, trying to do that. And so but we still do a will, because even if everybody's very diligent and we really think we've retitled all of your assets in your trust name, assets get missed. That old Exxon stock you got from your grandmother.
I know. I went through that with my deceased mother. She didn't have a will, but she did do, something else. But it turns out there were assets that were missed when I did a search through government agencies. Small things, but you still have to prove that you are entitlement to it.
And a lot of people try to get around. They think it's easier to instead of using a will or a will and a trust, is just put beneficiary designations on all their accounts, add their kids on, and or the worst is, and I'm always wary of this, is when people say, okay, I've got. My daughter is the beneficiary of my Edward Jones account. My son's the beneficiary of my Charles Schwab. And, years go on, you forget, you move assets, and all of a sudden, 20 years later, one child has been inadvertently cut out, which is another reason why if you name all of your assets in your name as trustee of your trust, then no matter what assets you sell, whatever happens, it'll still go on your death the way you want it to go.
That makes a lot of sense. What about revocable versus irrevocable?
Right. So when I say a living trust, it's a revocable trust. So that's the four, because what I'm talking about is the four basic estate planning documents: a revocable or living trust, will,
but you always do want revocable.
Yes.
Because this way it gives you power, right?
Exactly. And then, depending on your sort of tolerance for complexity and your assets, then we layer those four documents with additional assets or additional trusts. For example, if people have enough resources and they say, I really want to create an education trust for my grandchildren. I had a client I met with last week who said, I paid for the college of 3 of my 5 grandchildren. My youngest daughter's kids are still in junior high, and I want to be fair. Can we create an education trust that will be distributed, after when the youngest grandchild's is over 30 and has graduated from college? I mean, that's the great thing about estate planning is, so if you dream it and I can build it. I mean, we can. It's incredibly flexible, and pretty much anything that people want. I had another client yesterday who both of their children are on disability, and we have to create supplemental needs trusts for those trusts. So, but yes, the irrevocable trusts are very helpful, and they're in addition. They're not in lieu of your living trust, and it really helps to mitigate estate taxes. And that's one thing we can talk about that now. On top of that, the most important thing is to make sure your estate plan provides for your disability and the assets on your death are distributed the way you want them to. Then the other component is the tax planning. Illinois and the federal estate tax, and this is very confusing. There's separate tax structures. Illinois, you can exempt up to $4 million from estate taxes per person, so $8 million for a married couple. The federal estate tax exemption, they used to be unified. The federal and the Illinois used to be a unified exemption. It's not. Now, the federal exemption is $11.18 million. It's going up to $11.4 million in January. And so, on top of everything else, we layer this with, we want your assets to go to whom you want, but also we want to mitigate or eliminate estate taxes. And you can give an unlimited amount outright or in trust to a spouse. So typically we take advantage of that formula so that on the first death, the largest amount that can be sheltered from estate taxes is put in a trust, one trust, and then anything over is put in a marital trust for the surviving spouse. Another way to do it is to create gift trust during your lifetime, irrevocable trust. That would be an irrevocable trust. Or a trust, an irrevocable trust that holds life insurance. That's another very common irrevocable trust. And so there's a lot of moving pieces, and frequently, I've talked to people who have gone to other estate planners, and they give them a 20-page questionnaire, and they're overwhelmed. They don't get it done because it's overwhelming. But when I sit with people, I say, okay, what do you want to happen? Who do you want to get your money? And then I'll figure out a way to do it in a way that can eliminate or mitigate estate taxes and accomplish your objectives. And so the will and the living trust in tandem are the cornerstones for that. Then the other important documents are powers of attorney for property and health care. The power of attorney for property is effective only during your lifetime. So, and I tell clients, I say, which a lot of them do, they sign their wills and trusts and powers of attorney for property and health care. They go home and they throw it in a kitchen drawer. I give them a very boring funding memo when people sign their documents, going over in nauseating detail how everything should be titled in their trust name. And I always laugh and say, if you have insomnia, read my funding memo, because I know it's boring. And a lot of people will just say, okay, you know what, we'll get to that, and then they don't. And that's okay, because if something should happen to both of them, it's a probate estate, which is not the same thing as a guardianship estate. And if one of them would become disabled, that's the important thing about the power of attorney for property. The power of attorney for property gives your agent the ability to transfer assets into your living trust. So let's say something happened to your husband. If you're his agent under his power of attorney for property, you would be able to, and he was in a coma and unable to do anything. He would then actually be able to use that power of attorney for property and retitle any assets in his individual name into his trust's name. And that way we can avoid guardianship for disabled adult guardianship. I know I keep harping on it, but the more.
But you see it. You're in the field, and you see it all the time, and that's why you're doing this as a preventative protective measure, right?
Because that
for your clients.
That is probate. A decedent estate is not that big of a deal. Guardianships are so painful for the family, simply because the surviving spouse can't use the funds for, or the non-disabled spouse can't really use the funds for herself or himself. It can only be used exclusively for the disabled person. It's a real nightmare. So the power of attorney for property does that. The other addition with the power of attorney for property is that is the electronic assets, because when I first started practicing law, email was in its early stages. Everybody got hard copies of statements. These days, more and more people only get everything electronically, and a lot of people don't know people's passwords. I don't know my husband's passwords. He doesn't know my passwords. And I remember I had to threaten to sue Google. I got a court order because I had a client whose son was a millennial and he died suddenly. And on top of grieving, going through the grief process, we were trying to figure out what assets he had and have access to his accounts, and we couldn't do it. We had to get a court order, and even with a court order, they were Google was still. I love Google, but I have to say I cut off my Gmail account for about 10 years after that experience. But now with the Digital Assets Act, we don't have to worry about that, because as part of the Illinois Power of Attorney for Property, it specifically gives the agent the ability to manage your digital assets. Also, in my wills and trusts, I specifically give the executor and the trustee that same authority, because people don't know what people's passwords are, and it's.
I wouldn't think of that. I mean,
no, I know,
and
it's
so informative.
It is.
Yes.
Well, it's very helpful to have this, because before we were just, we were struggling trying to get access people's information. So that's huge. So the power of attorney for property is the third really
How should
important
you
document.
title, if you have a couple, how should they title it, which would be give the other surviving spouse most protection?
Well, they should title it in their names as trustee of their respective trusts. And there's lots of ways that can be done. You can split up the assets. You can, sometimes couples who've been married for 30, 40 years say, you know what, this doesn't feel right. We've had our assets have been joint our whole marriage, and then I say, that's fine. So we can set it up so that it's as tenants in common with each of their living trusts as an undivided 1/2 owner. So, it really doesn't, for Illinois purposes, you really sort of need to split up your assets for estate taxes. But as long as it's in one of your or both of your trusts, that's the important thing. And so, and even your residence, you can. Illinois has this thing called tenancy by the entirety, which is a nifty thing because it gives creditor protection. If you hit a school bus, your creditors can't force your husband to sell your house, and even now Illinois has allowed each couple's 1/2 interest in trust to be done as tenants by the entirety. So it really, from a creditor protection standpoint, Illinois is not one of those states like Nevada, for example, that has these self-settled spendthrift trusts that you can protect your own assets from. But there's lots of other ways we can do it. So that's your power of attorney for property. And you can decide if you want your power of attorney for property to become effective immediately, or only if you once you're incapacitated. Only a lot of people, say if they're married, they say, I'll let it be effective immediately for my spouse, but for my successor agents, who might be my kids, adult kids, only once a physician is certified that I'm not able to manage my financial affairs. Something like that. So, and then the other document is the power of attorney for health care. And that's just what it sounds like. It gives you the...
like a post.
Exactly,
Right.
exactly. So it gives you the power to make health care decisions only pretty much if you can't, you can't make the decisions yourself.
And then again, because that can be a temporary condition where you can't, you had surgery, you're in a drug-induced coma, whatever the situation is, but then once you regain your cognitive abilities, you can go back, or is that more difficult too afterwards?
But you know what? No, because the Illinois has both the power for property and the health care power are statutory forms. But within the statutory form, there are options, and one of the options that you can pick is I want the power of attorney for health care effective only when I can't make my decisions myself, or effective all the time. Most people pick only when I can't make the decisions
you can't make
myself.
it at that time.
Exactly.
So then you don't have to fill out anything, you don't have any legal documentation or physician's documentation.
Right.
So, then that goes back. What about pension plans, IRAs?
Pension plans, IRAs, now, it used to be that you can't people ask me this all the time, you can't put your trust in, you can't name your trust as the owner of your retirement assets. Any assets with a beneficiary designation, you typically name your living trust as the beneficiary. With retirement assets, because if you name a surviving spouse as the beneficiary, they have the ability to roll over those retirement assets typically, and take them over their life expectancy, and the required minimum distributions are smaller. I typically recommend naming your spouse as the primary beneficiary, and your living trust as the backup. It used to be that you couldn't name your trust as you couldn't name a non-person, non-entity as the beneficiary of a retirement assets. Otherwise, it would recognize immediate gain on all the assets.
Oh,
the IRS has softened on that, and if you do what they're called conduit trusts, where you use the oldest beneficiary as the measuring life for the required minimum distributions. You can do that. So a typical estate plan is if there is a surviving spouse, and that's consistent with their wishes. Again, we don't want to put the cart before the horse. If it's a second marriage situation and there's a reason why they don't want to name the spouse as the primary beneficiary, then we'll name their trust immediately. I mean, and that's actually another issue. Sometimes people don't want to do an estate plan because it's complicated. It's messy. Life is messy.
Life is messy. It's
everybody's married now. They're on their second spouses or third or fourth
marriages,
and there's children, mine, yours, ours, and it's and sometimes people don't want to do their estate plan because they don't want to address it. But that can sometimes have disastrous consequences. It's much better to face it head on.
Absolutely.
So, and then going back to the healthcare power, the other thing that it does is the use of life-sustaining treatment. A lot of people have very strong feelings about it. And the Illinois statutory form, it actually used to be better because it gave you 3 choices that you could select that reflected your wishes. Now they tried to simplify it, but they kind of dumbed it down because it's now just 2 choices. But having said that, people are free. Sometimes people have very strong feelings about specific types of life-sustaining treatments, and you can put that. I mean, and that's and that's really, some people it's really important to them. The other thing that's really important that people need in an estate plan is the disposition of their remains. A lot of people have very strong feelings about it. For some people, absolutely want to be cremated. Some people say, I'm terrified of being cremated. I don't want to be cremated. And it's doing an estate plan forces people to sort of communicate, articulate, and communicate. What they want. And it's surprising how frequently people don't talk about it. I've been married for 20 years. My husband shocked me the other night at the dinner table. He said he wanted to be cremated. I was like, wow, I'm glad you told me. I would have stuck you in the ground someplace, So
I'm going to be in cryonic suspension.
If you want that, you need to tell me that.
Absolutely.
And that's something, particularly if you've got very strong feelings about that, an organ donation, for example, it should be in your will and your power of attorney for health care. Because although your power of attorney for health care, along with your property power, terminates on your death, sometimes when people are at the hospital, nobody has your will. They have your power of attorney for health care. So it's good to have it in there.
Very good. I have to say we're almost out of time, and I did want to just briefly, I think we probably have 1 minute left, changes 2019. Do you know of any? Yes.
Well,
really quick.
Income taxes have killed the property taxes with the itemized deduction. So that just stinks. There's no other word for it. Estate taxes are just an absolute mess. Which it's funny. Their estate taxes right now for Illinois, it's stuck at $4 million. They've talked about raising the exemption, lowering the exemption. I don't know what's going to happen with Illinois. Federal exemption, this huge amount, starting January, $11.4 million, absent further legislation, is going away in 2026, and it goes back to $5.6 million. So depending on your assets, this is. I don't think that they're going to. I think they're going to let this tax law sunset. So go to your estate planning attorney, particularly if you've got a taxable estate. If you have an estate over $4 million, you need to go to your estate planning attorney.
Very good. So we've just touched on this, and I have to thank you because there's so many things that are coming up as far as different laws and avenues and what about if somebody doesn't have a great deal of money? What do they do then?
they still, you know what? I do estate plans for people with 200 million. I just did an estate plan for a nanny.
Okay,
because,
so we do it all.
yes, I do. Everybody needs an estate plan, and I make it happen because I really want everyone to have an estate plan.
Yeah, you're a wonderful, wonderful attorney who can say that, and I look forward to doing another program.
Thank you. Well, thank you for having me on. It was a pleasure.
Thank you for